Hello, welcome to the Rights View channel. I'm Mizoram Chakma. Today, the Guwahati High Court has declared the Mizoram High Technical Courses Rules 2016, known as the STEE Rules, as unconstitutional. These rules have deprived Chakma students access to higher education, such as education in medical and engineering colleges. This is a historic judgment not only for the Chakmas of the state, but for all other minority communities all over the country who face the brunt of similar policies of exclusion and discrimination at the hands of state governments. Today we have Mr. Suhas Chakma with us. Suhas Chakma led the initiative to challenge these rules before the court of law. He will be explaining the various aspects of these STE rules. To start with, Mr. Chakma, can you tell us what does this STE rule say?
The STE rules we have brought in 2015, and prior to the STE rules from 1999 till 2015, the Chakmas and all other scheduled tribes of Mizoram we are treated as one category. Then in 2015, the Mizoram government brought the STE rules to divide the candidates from Mizoram into three broad categories. Category 1 belonging to the Jo ethnic communities, which they explained or perceived as only Mizos, and non-Jos, which basically meant the Chakmas and all other scheduled tribes, and category 3 is basically the non-tribals living in Mizoram. And under these rules, 95% of the seats we are reserved for the Jos, who constitute actually only about 73% of the total population. 4% we are reserved for the category 2, which is the non-Jo students. So this deprived the Chakmas access to education, because the Chakma students were denied admission in MBBS and Engineering colleges. And in 2015, the Mizoram Chakma Students Union challenged the constitutionality of the rules, and the state government at that point of time actually gave an undertaking to the High Court that they shall withdraw the rule, and they actually withdrew the rule. So the case was disposed of as being withdrawn because it has become infructuous given that the state government has already withdrawn the rules. Then in 2016, actually Mizoram government again brought the same rule by tweaking one word here and there, which basically meant that again 95% of the seats will be reserved for the Mizo students, 4% of the seats will be reserved for the category 2, which is non-Jo students like the Chakmas, Brus, and the children of the central government employees posted in Mizoram, and category 3, which basically meant that non-tribal living in Mizoram. So this effectively meant that the category 2s, which are non-Jos, that's 14 scheduled tribes outside the Lusais, as well as the children of the state government who were on deputation from the central government, they constitute about 25% of the population, and they shall have only 4% of the seat. So that was the STE rules all about, that it was a means to identify the Chakmas as a general category candidate, and the Chakmas obviously we are deprived, so they had no other option but to challenge before the Guwahati High Court as to the constitutionality of the rules.
So why has the Honorable Guwahati High Court has declared its rules as unconstitutional?
We are yet to read the full judgment, but the submission of our legal team was very clear. The first principle was that the list of scheduled tribes prepared by the President of India cannot be tinkered with by any state government, and you can tinker with the list of the scheduled tribes only with the permission of the Parliament of India. That's through the approval of the Parliament, which is to be notified by the President of India. There is no state government which can tinker with this particular list prepared by the President of India and notified as such by the President of India. So that's one issue. The second issue is that the scheduled tribes, once the list is prepared, they are one class of persons regardless of their ethnicity, race, origin, etc. So therefore scheduled tribes are a homogeneous group, and the moment you try to bring an amendments or tinkering or classification, sub-classification whatsoever within this list prepared by the President of India, you are actually violating the Article 14 of the Constitution of India, which basically amounts to reverse discrimination. And third, the Mizoram government, what they have done by putting the Chakmas and non-Jos into category 2, they basically put all the Chakmas and other non-Jos into the category with the students or the children of the Government of India, central government's employees posted in Mizoram. So in a way, what you have done, you have actually deprive the Chakmas of being notified as a scheduled tribes, because for the 4% of the seats, Chakmas had to compete with the children of the central government officials posted in Mizoram. So this effectively means that you are no longer being treated as a scheduled tribes. Actually, you are being treated as a general category student in Mizoram, and that's one of the serious concerns which the Chakmas had. And on these three grounds, I think the court was convinced, given the fact that there have been numerous judgments in the Supreme Court by the Constitutional Bench of the Supreme Court declaring such categorization, sub-categorization, or tinkering with the list of the scheduled tribes. And in fact, the Supreme Court was very clear that in the case of Andhra Pradesh reorganization of scheduled caste list, that the state authorities, including the Assembly, did not have the competence to enact such a law, because only the Parliament of India and the President of India are competent to actually tinker with the list prepared. And the same was done, in fact, when Article 341 and 342 was being brought in a Constituent Assembly. One of the arguments used by Dr. Ambedkar was that the state government should not take decisions based on the political consideration, and in that case, obviously, large number of minority communities will be affected, and that has prevailed in the judgment.
What is the submission made by the state government of Mizoram?
See, the state government basically said that if the Chakmas are given category 2, in that case Chakma students will get more access to education, because the Chakma students cannot compete with the Mizo students. But our council had highlighted that that is not the case. The case is that the Chakma students are no longer competing with the Mizo students. The Chakma students, we are actually competing with the children of the central government officials who belong to, higher echelons of the society, the IAS officer, IPS officers, etc. being posted in Mizoram. Can the Chakmas actually compete with these students? Obviously not. So this was not the case of providing access to better facilities. Actually, it was a case of, as I said, putting the Chakmas in the general category through the back door.
So now, what happened to the Mizo students who have taken admission last year during the 2018 academic year? During the time when the court actually have, while modifying the stay order, had said that this admission is subject to the final outcome of this PIL.
This issue actually was raised by the Honorable Chief Justice of the Guwahati High Court, and we basically said we do not want to press this issue, because the students who have taken admission already and their academic future should not be destroyed in that sense. Obviously, if the Chakma students had suffer, that doesn't mean that you are going to make other people suffer from this. So the admission which has already taken place will not be affected by the judgment, but obviously the judgment has to be applied from next academic year, which is coming this year.
So how do you describe these STE rules in the context of Mizoram?
This was an unfortunate initiative which was taken by former Chief Minister Lal Chanwala. I think it was an initiative to divide Mizoram, because at the end of the day, if you believe in Mizoram as a state, it is essential that the state government, whichever party is in power, actually take care of all the people who live within its jurisdiction. And if the state doesn't respect the laws, obviously you cannot expect the other people to respect the laws. So therefore, if I look at it, it was an unfortunate initiative, because Mizoram shall never develop with the development only one community, irrespective of whichever it is. So therefore, the legislation which you brought actually was harming Mizoram more than anything else, because in Mizoram it should not be only for the ethnic Mizos, just the way we define India. See, India is not only for a particular religious community, say for example the Hindus. It consists of so many communities, religion, belief, practices, and etc. So within Mizoram you also have different communities, and you should actually promote this plurality and promote the development of all the communities, so that Mizoram develops. And this was, I would say, an extremely negative step taken by the Chief Minister, which harmed the Mizoram as such, because Mizoram consists of all the people who live in Mizoram and not only one particular community.
Can you tell us about the challenges faced by the team while pursuing this petition?
I think we faced many challenges. One of the challenges faced was by President of the MCSU, Mr. Chakma, because he was threatened a number of times to withdraw the petition. And second issue was, of course, because you live in Mizoram and he filed the petition itself was actually dismissed first for non-prosecution because he was not informed about it, and the High Court was very kind enough to restore the petition. And finally, of course, the parents of the students who were affected, they were very impatient because the judgment took a long time. So there was pressure from the community as to what is happening with the petition, and so these are, I think, natural expectation of the people who do not know. There is a huge amount of judicial delay in the country, and we are in fact delighted that it could be adjudicated in such a short period of time despite all the obstacles which we faced.
Is there a possibility that the state government might in fact bring a similar rules again like it did in 2015?
I do not think there is any possibility to bring that kind of a rule once again. In 2015, the state government actually withdrew the rules on the ground that they will not bring back the rules, and there was no judgment. So at the preliminary stage itself, the petition was disposed of. But in this case, there is a judgment, and you cannot bring a law which has already been declared illegal. It will be a case of res judicata, meaning something which has already been adjudicated, you cannot bring a law on that. And of course, you have to bear in mind that the current state government may have a different view from the views which was held by the previous chief minister. And of course, if they bring a law, there is no other option except to approach the court of law.
Thank you very much, Mr. Chakma. It's a historic judgment not only for the Chakmas of the state, but for all the vulnerable communities, minorities in other parts of the country who face similar exclusion and discrimination at the hand of the state governments. Thanks for watching. Please do subscribe to the Rights View channel.